All right, great, excellent. So I want to welcome everyone to today's webinar. Today's webinar is going to be focused on construction defects during COVID-19. I want to thank first and foremost Stephanie and Ashley for helping put this event together, and also the team there at M2E. Very appreciative for all the efforts that they've done to help make this webinar happen. Second, I want to thank all the board members and managers that are here in attendance today. It really goes to show the level of commitment that you have as both board members and managers to receive additional education on how to deal with the challenging times that we're dealing with, as well as the day-to-day that we always have to deal with. So before we get started, I wanted to do some introductions because I do have the honor of having two excellent panelists here with me today. First, I want to start off with Nick. Nick is a shareholder at the law firm Siegfried and Rivera. Since joining the firm in 2006, Nick has concentrated his practice in areas of construction litigation, condominium law, and community association law. In the construction sector, Nick represents owners, developers, contractors, subcontractors, material suppliers, and design professionals at all levels of the construction process. I also know, Nick, that you've had some really significant large construction defects claims. Specifically, I always remember that $22 million case that you won there in the Brickell area. So welcome aboard, Nick.
Thank you. Thanks for having me.
No problem, my pleasure. Next, we have Misha. Misha's experience in engineering and construction spans over 30 years. During that time, he has overseen projects ranging from multi-purpose conference halls to luxury condominiums across 3 continents. As founder and president of M2E, he has led project management, owner representation for both financial and construction, and quality control for various multi-million-dollar residential and commercial projects for a combined value of several $billion to date. An experienced engineer and a proven problem solver, Misha has actively participated in all aspects of the construction's process throughout his career, from design and construction management to equipment commissioning and forensic engineering. I want to welcome you here today, Misha, for being on the panel. Thank you.
Thank you. We were the engineers on that $22 million claim.
Oh, look at that. A 1-2 punch we have here today.
Yep.
Excellent. And as for myself, my name is Rafael Aquino. I'm the co-founder and CEO of Affinity Management Services. Like Misha, I also have an engineering background, which has equipped me with the ability to manage the challenges of community association management. My team and I manage properties throughout Miami-Dade, Broward, and Palm Beach County. And we have the pleasure of serving over 50 condo and homeowner associations in the Tri-County area. So again, welcome all those that are here, and I think we'll just get right to it. So yesterday, we had a little pre-game with regards to our webinar, and I know Misha mentioned how the 558 process and the construction defects all started. So Misha, I guess if you can kick it off and give us some background when it comes to that and why all of that came about.
Well, I think that the general flavor of this seminar being 558s and how to do them in the age of COVID, the whole idea of the transfer of control of the association from the developer to the association is something regulated by the Florida statute. And the 558 process itself, which is named after the number of the Florida statute that it pertains for, became enforceable on residential properties, on multi-residential properties in, I think, 2004, 2005. And what it essentially did is the actual 558 process was heavily lobbied for by the contractors who were unhappy about this old turnover process, how we used to call it. And essentially, contractors were unhappy with the fact that they were saddled with multiple claims that were not proven in the field. That was their, I guess, interpretation of it. In as much that they were saying, well, if you show me in 3 instances, that doesn't mean that it's a project-wide issue. At the end of the day, the 558 process was, as I said, uploaded, so to speak, on multi-residential and condominium properties, which resulted in the process itself changing. How did it change? It changed by providing what was called an alternative dispute resolution process. It's a very fancy way of saying, this is what you need to do before you sue me. And it is mandated because that's how the law says it. You have to do this before suing me. The process itself, the idea of the process was, the contractor's idea of the process was that by making harder on condominiums to prove their claims, by having to show every instance of where something happened, they would actually dilute the claims and make it harder for condominiums to prove their cases. Well, that changed the game in as much that firms like Nick's and mine now had to go to a statistician in order to prove in a statistically significant sampling way that something that happened in 5 or 10 or 15 instances is actually a project-wide issue. The contractors were still kind of reluctant to go through the process itself because it had proven to be very expensive from the standpoint of legal fees.
Yeah.
And it's because if you look at the way that you defend this is the general contractor has his own attorney and all of his subcontractors have their own attorneys. So the process itself was costly to defend. And there was not, although they were the one who actually lobbied for, there was not a clear embrace of the product from the contractor side, although it was actually designed to make it tougher on the condominiums. Well, subsequently what happened in a Florida Supreme Court case, Altman v. something, the Florida Supreme Court ruled that the insurance company of the contractors and developers have a duty to defend. So suddenly now the cost of the defense was, quote unquote, paid by the insurance companies. Well, the insurance companies were not happy about it. However, they had to do it because that was the new law of the land. How did that change the process? Back when Earth was young, before 2004 and before 558, we used to sit, we, the condominium representatives, used to sit with the developer and the general contractor, and the association, 4 people in a conference room: developer, general contractor, association, and representative engineers, either on one side or on both sides. The 4 people would sit down, we would make a list of our griefs, we will agree on some, we will disagree on some other, and then the developer would make the general contractor and its subs perform the majority of the work that were disputed.
Interesting.
So it was fairly a streamlined process, and in that way, it was kind of less players in the room, so less variable to coordinate. The way that 558 works now is, are you ready for this? It's going to be a long-winded one. Because the insurance is the obligation now to defend it. You have the developer, the developer's attorney, the developer's insurance, the developer's insurance attorney, the developer general contractor, the developer general contractor's attorney, the developer's contractor's insurance, the developer's contractor's insurance attorney, and this for every of the subcontractors that is on the list.
Wow.
So what used to be walkthroughs of 5 people are today easily walkthroughs of 50 people. And what used to be a 1 day of walkthroughs to prove claims are now a week of walkthroughs.
Wow.
So the process that was supposed to streamline the process is now become very cumbersome. And at the same time, the format of it is quite bulky. The way that the 558 is negotiated has suffered as a result. Well, changed. What used to be, let me show you what is broken so you can make your general contractor fix it, or make your general contractor make his subcontractor fix it, is now just how much does it cost?
Yeah.
The insurance people do not perform work. The general contractor gives the key of the negotiation to the insurance people saying, I pay my deductible, have a nice day. What you do is, I don't care because it's your money. Insurance representatives and councils are typically bulk billing councils, and they have no incentive of being efficient. So a process of weeks become a process of months. And at the end of the day, you end up with a magic number that the association is least unhappy with, and that the same magic number is least unhappy with by the insurance who is going to write that check.
Gotcha.
That's how the entire process evolved. And when we now talk about hiring statisticians, well, exotic person, right? It's because Nick and I play this, what if we don't settle?
Okay.
What if we have to be in court like that $22 million case?
Yeah.
The first thing that the general contractor and developer is going to claim, number one, it's maintenance. So I didn't break it, you broke it, association. Oh, by the way, I gave you control on Tuesday, and it's your maintenance from Tuesday to Thursday that broke it, not my maintenance of the 2 years before.
Are you sure?
Number two, and number two, you didn't show me where it all happened. One of the rules of 558 is if you can't show it to me, I don't owe it to you. Wow. And the associations which come from a space of this is my home, don't understand the business side of if you don't prove it, I don't care.
Yeah.
So we, the engineers and the attorneys, have to play the game the way that it's now ordered to be played. So when we say to an association, we need to hire a statistician because he will give us the sampling that will give you tomorrow in court the probability that can make you win this case. If they don't settle, they need to understand that it's a must, it's not a would like to. And at the same time, we frame this, the attorneys, Nick's firm and myself, we frame this in the, we would love to settle and we intend to settle, but you need to understand that we are prepared to fight this, which is what makes insurance come to the table. If the insurance company has any opportunity to wobble, they will. Remember, they know that there will be a check written at the end.
Of course.
Every day that they don't write that check, they use that money for other purpose.
Yeah.
So you want to be able to get the insurance to the point where they have no other choice but to write the check because next Tuesday is court time. And I think Nick is going to talk about that because court time now is moved, right? Because in this situation. Yeah. But that's kind of the, as broad brush as possible of the process itself. And that leads to, you know, the selection of the right professionals.
Of course. And I know that you know, this has definitely dragged times, and now in the midst of COVID, imagine trying to have all those people into the unit. But before we kind of go into that, I want to kind of take a step back and maybe, Nick, if you can give some of the listeners, because while some are probably well-educated and know the whole process, I think for those that may not have all the knowledge, if you can give us a little bit of an understanding of how the statute works when it comes to its limitations. What are the timelines that are necessary to be able to file this claim or to get the process started? Okay.
Yeah, I think Misha gave a great overview of the 558 process. I'll try to fill in some details on it. So like Misha said, the 558 process was enacted 2003, 2004 as an alternative to litigation. And the statute requires that 120 days prior to filing a lawsuit, the association is to give notice to the developer, to the contractor, to the subs of the construction defects. And then within 50 days of that notice, the parties have the opportunity to inspect the property, which is what Misha referred to in terms of the inspection, when you have possibly as many as 50 people attending these inspections. It's a right provided by statute. The association needs to comply with that right. And if the association doesn't comply with this pre-suit requirement of notice and inspection, the association won't be able to proceed with its claim. So you have the inspection, and then 75 days after the notice goes out, the contractor, developer, subs, suppliers are to put together a response as to what they are willing to do. The statute gives certain different options to the parties. One, they can just say, we're going to write a check. This is the amount we're going to pay you, and we're done. See you later. Yeah. It can be, we agree with these items. We're going to repair all the items, and we want to release, and we're done. Be subject to additional negotiations in terms of, well, how are you going to repair it? what is the warranty you're going to give for any repairs. Misha and I have been involved in projects where the developer and contractor say, hey, we'll take care of it. Don't worry, we're going to repair it. And then we say, okay, that's great. How are you going to repair it? Oh, yeah. Why do you need to be worried about that? You weren't worried about how we built it. Why do you care about how we're going to repair it? That's none of your business. We'll just take care of it. We'll give you a warranty. Well, our position is no. It's our property now, and we know it's defective. We want to make sure that the repair is not going to lead to other issues, and it's actually going to take care of the defect. So in those instances where the developer says we want to repair something, we say we want a repair protocol. And it'll list, hey, this is how we're going to do it. If we need revised plans, if we need to pull a permit, if we're going to give you the material we're going to use, and that'll all be reviewed by somebody like Misha to say, yes, this repair is acceptable. If the repair is acceptable, then the association can allow the repairs to proceed and receive a warranty also for the repair. The other responses could be a combination of money, like Misha said, or it can be a combination of repairs, or it can be, in some instances, just a denial of the claim. We're not going to do anything. And we're going to, and then the association is left to determine how it wants to proceed. But I'll back up a little bit right before the 558 process, because I think the 558 process, not only when people talk about it, talk about the statute and the requirements of the statute, but 558 is also, I think a lot of people talk about it generally in terms of the turnover claim. So what is involved in a turnover claim? And I think a turnover claim starts at the beginning. It starts really the day of turnover.
Correct.
From the developer to the association, to the unit owner controlled association. And one of the things I think that is key from the beginning, and something that's so simple, that needs to be accomplished from day one at that turnover meeting or immediately thereafter, is that the unit owner controlled association needs to make sure that they get certain documents that are required to be turned over by the developer at turnover. Okay. And probably the most important, I'll go through the list of there's a number of documents, but I'm going to focus on the ones that are most important to a 558 claim, construction defects. The first document, and this is required by statute 718-301, the turnover statute. It requires a copy of the plans and specifications utilized in the construction or remodeling of improvements and the supplying of equipment to the condominium, and in the construction and installation of all mechanical components serving the improvements and the site, with a certificate in affidavit form of the developer or the developer's agent or an architect or engineer authorized to practice in this state, that such plans and specifications represent, to the best of his or her knowledge and belief, the actual plans and specifications used in the construction of the condominium. It's key that the association receive these plans along with the affidavit at the time of turnover or immediately thereafter. Misha and I see what developers typically use as a developer turnover checklist. They'll have all the requirements of the statute, and they'll basically have it's a checklist. They'll say, hey, we gave you this, we gave you the plans and specifications, we gave you the list of all the names of the contractors and subcontractors and suppliers that worked at the condominium, copy of the CO, a copy of any applicable permits, a copy of any warranties, and then it'll be a list, and they'll say, we gave it to you, or we haven't given it to you, it will be provided. And I've seen recently on a project where probably the most important thing, which is the plans and specifications certified by the architect, to be provided.
Correct.
We're a year, I'm getting involved in this, and we're a year out from turnover. And now I'm saying, guys, was this ever provided? No, it wasn't. So now I got to go back to the developer and ask for these documents. And the developer is going to provide it, but in some instances, the developer may not be around anymore.
Yeah, it becomes a cat and mouse game.
Back in 2006, 2007, the developer may have been bankrupt and gone.
Yeah.
And care less about the project.
Correct.
So this is one of the key things that needs to be accomplished early on to make sure you get the documents, because as an attorney, it's a basic thing that I need to establish. What was required to be built in this condo? And I need to show the jury, well, here's the plans and specifications. This is what was required, or this is what was built. And it's Misha's obligation to say, well, now we have the plans and specifications. Let me tell you why they didn't comply with the plans and specifications. But on a condo project, talking about a 50 story high-rise building, you can imagine all you have the original bid set of documents, of plans and specifications. Then you have a permit set. Then you have revisions, because in any building you're going to have revisions. People are going to do things differently. They're going to determine that things just don't work the way originally planned, or the contractor is going to run into problems. They're going to need to go to the architect to say, hey, what you designed is not working. I need to change. Then there's, of course, value engineering. We can do things cheaper, and we need to revise the plans. Then there's, of course, change orders. Everyone's heard of the change orders. Not one project doesn't have a change order.
Yeah.
So that resulted in a revision to the plans. So there's so many iterations of these plans and specifications that will be in the developer's records and the contractor's records, and even with the city, so many variations of the plans that Misha and I have faced in other projects where the association never got these documents at the beginning, where the developer and contractor, you ask them a simple question, hey, where are the plans for this building? Or let me show you what I believe are the plans. Can you confirm that these are the plans? Their response is, well, I don't know if those are the plans. They may be the plan. They look like the plans. They've been revisions to the plans, so I can't confirm that those are the plans. So, as an attorney, I see a lot of waste in litigation. Like Misha said, people just are, the defense is billing the file and pushing the file for, no goal of concluding it. Yeah. And this is just another layer of a way to defend the claim and to make it more difficult in what should be a very simple process at the beginning. Hey, developer, you built it. Tell us what you built. Give us the plans. Yeah. So that's a day one issue. And then also.
Now, Nick, if I can kind of ask you a question, because you're stressing on the plans, and I'm going to let Misha talk on the plans, because I know there's particulars that he wants to address. What can, like, the managers, or because during turnover, they're turning over the association. So at that time, the board may have not hired an attorney yet, depending on the board and their knowledge or their experience, or better yet, their network, will be able to gauge, they'll be able to do that process properly. But what would you recommend for the managers and new boards that are going through a potential turnover process to be able to make sure that information is handed over? Because as you stated earlier, it is within statute. I know we've dealt with several turnovers, and honestly, it's like pulling teeth. But our recommendation is clearly let's get an attorney involved earlier on before this process, because there's already a board that you kind of have an idea of who's going to be on that board. But what recommendations do you have from a legal side that the new boards or new managers should be keeping in mind?
I won't make any recommendation on the legal side because I'm not licensed to give those. However, on the experience side and the engineering side, what I can say is the following. The main reason why as-builts, we call them as-builts, which is the actual, actually the term actual plans used in the erecting the improvements do not have to be as-built. They can be the trailed and folded and dirty set from the job site, marked up with the blue pen and red pen of the superintendent. That's fine. It doesn't have to be a pretty one that is stamped as built, but it has to be representative of what was built. I go to causation typically because engineer, right? The main reason why as-builts are not provided, in our opinion, is typically because the generation of the as-builts is never in a contract of that an architect and design engineer has. So here we are, it's the end of the project. The developer already spent all of his money. He's struggling with the closings, And then he says, where is my as-built? Architect says, you didn't pay me for the as-builts. Here is a bunch of frailed and marked up blue, green, yellow sheets from the general contractor and his subcontractor. I need to put this in CAD. It's going to cost you X amount of dollars. The developer goes, I'm not paying you. I'm the end of the project. And what the architect says, I'm not doing anything. So the association ends up being stuck with what is the last filed revision with the city. The problem that we have, Nick and I, is to actually make the manager / condo understand that we only need a representation, what Nick says, certified by the developer or its professionals. If the developer chooses to give you the wrong set of drawings, but certifies those as being the ones that he built the building, you, the association, is authorized to rely upon those, to hire the engineer and the attorney to enforce those. So if he value engineered the fountain at the entrance of the building, yet the set of drawings that he gives you has a fountain at the porte cochere, he owes you that porte cochere's fountain according to Florida statute.
Interesting.
The way that I'm angling this is, the sooner you get an attorney to explain this, just like I did with the porte cochere fountain thing. Hey, Mr. Developer, we need a set of drawings that you're going to tell us and swear that it's the ones that you use. Which one you're going to give us, we really don't care. But you need to give us a set so that the attorney and the engineer have a baseline to go and inspect.
Of course.
Oh, by the way, if it's not updated, we will make sure that what is on the drawings is actually in the field. So be sure. Your choice. And that way you kind of corner it in a situation where he has to give you something. He may even go into his wallet and pay the architect and the engineers to do it. He may actually at that point have to do it because he exists, to Nick's point, he exists. And the 558 just started. The worst thing that we can, and that's just the condo that Nick's partner and I are doing right now, is the developer gave a set to the condominium. It was stored under the stairwell and the flood destroyed it. So
dog ate my homework kind of trick, huh?
so you remember on Tuesday, 8 years ago when I gave you that? Yeah, it was like that. So if possible, our recommendation is to have it in a digital format so it can be flooded under the stairwell. And because there will be a second, third, and fourth board, and there will be always a discussion at some point, what did we really buy or what did I buy? Subsequent buyers will ask for what did they buy. We recommend to get it and then digitize it so it's easily transferable.
Excellent. Thank you, Misha. So I do want to touch on, Nick, is there anything that the managers can do to or the transition to really make sure that information is provided in at turnover?
Well, yeah, I mean, typically the management company is in there before turnover.
Sure.
And I think there is, and maybe you could speak on it, there is a coordination between the developer and management about the turnover of documents and what documents the developer has and organizing those documents to be able to provide to the association. My advice to any turnover board is don't sign anything.
Yeah.
Whether it's a release, which we've seen developers push in front of owners or the new board members at turnover and say, sign this release, it's part of the turnover, which is crazy, but we've seen it happens, to the turnover receipt of the documents, meaning, oh, board, here's a box and all this stuff that you're supposed to get is in there, and can you just sign that you've received it? And I would say don't sign it. Yeah. Say like, as a board member, as a lay person, how are you supposed to know whether you've received these documents or not? You're relying, like in most things, you're relying on the advice of your management company, your attorney, and your engineer. So why should this be any different? You should say, okay, I understand you've given these documents. Okay. We're going to retain an engineer, we'll retain an attorney, and we'll review these documents. And if these documents are what you say they are, we'll acknowledge receipt of these documents at a later time. well, we want to review them, because we've also seen it where the developer shows up and says, oh, I have the receipt, I gave everything to you, and the board is maybe a new board, the management company is no longer there, or they're there, and no one knows what happened to these documents.
Yeah.
So even if they are provided in paper copy, we want to make sure to digitize them, to make sure we have them, to make sure it's organized for the board, for management, for the engineer, because they need to make sure that this information is not only available for 558, but for future use.
Of course.
And the other thing is the developer, and I don't know how many people would know this, but the developer is also required to provide a report to the associations under seal of an architect or engineer, attesting to required maintenance, useful life, and replacement costs of the following applicable common elements, which is basically the most important things: roof, the structure, the fire protection system, elevators, mechanical, plumbing, electricals, pool, seawalls, drainage. And probably the most important thing about that report is they're supposed to tell you what maintenance is required for the elements. Because another defense that Misha and I see, and he started off with it, hey, you didn't do the right maintenance.
Yeah.
And then the question is, what maintenance did you think I was supposed to do on it? Well, and trust me, they won't tell you.
Yeah.
But if they're supposed to give you a report saying what the maintenance is, then at least you have a document that you can go back to and say, well, this is the maintenance you told me to do, and I did this. So you can't now request or expect that we were supposed to do additional maintenance. So these kind of things, are very important at the beginning. And one other thing I'll talk about the beginning of the 558 claim is, and again, this is from experience, is the new board will come in, and there will likely be an attorney at that turnover meeting.
Yeah.
Handling the turnover on behalf of the developer. And in some instances, this attorney gets promoted to the new board by the developer as, well, this is the attorney for the association.
Yeah.
He's been dealing with collection matters, general day-to-day stuff with management, helping the association. He's really the association's attorney, and feel free to use him as your attorney going forward on your 558 claims, after turnover or anything else you have, because this is the association's attorney, not the developer's attorney. Well, think about it. Who put this attorney in as the association's attorney pre-turnover?
Of course.
The developer did.
Yep.
And do you think he has a relationship with this attorney? Yeah, I can tell you he does have a relationship with the attorney. You think the developer tries to get the attorney in with other associations prior to turnover? Yes, and he does. And this happens a lot.
Yes, it does.
What you have is an attorney pre-turnover that is friendly to the developer. Okay? So the new board needs to, at the very beginning, start asking questions. Okay? Because it's going to have to hire an engineer and an attorney, or at least it needs to consider these things immediately after turnover. Now, if there's an attorney there, well, who is this attorney? What is the relationship with the developer? The board should be asking those questions. They have the right to know, okay? And it's certainly a valid question to ask. And then same with engineers. When engineers come in to interview with the new board, hey, do you have any relationship with the developer? Have you ever worked for the developer? Did you work for the developer on this project? Because we have found that developers will work through even sometimes management companies to promote certain attorneys or to promote certain engineers.
Correct.
So it's fine, certainly fine, and we recommend getting referrals from the management companies as to, hey, who do you recommend? Who have you used before? Yes, the management company should be recommending attorneys and engineers. But it's certainly a valid question to ask, well, is there any relationship? Have you guys worked together? What other projects, and in what capacity have you worked together? Because we have seen situations, and we wrote an article about this called stacked boards, where you have not only attorneys and engineers and perhaps management companies that are friendly with a developer, but now you have board members that with a developer. a realtor the developer works with that sold a number of units, represents a number of foreign investors. And hey, they represent 25 owners. Well, that's 25 votes they just got for the board.
Correct.
And now who's their allegiance to? So even if you're not a board member or you're a unit owner, those questions need to be asked, because this is the beginning of a process that's crucial for the life of the building. This is we get one chance to do this the right way. And, like you started saying, hey, we got a $22 million settlement. We've also, gotten other, certainly multi-million-dollar settlements for our clients. Well, what happens if you don't get that? What happens if you just agree to, aesthetic repairs for something that's a much deeper problem?
Correct.
Well, who's going to be paying that? Unit owners.
Correct.
And they're going to be wondering how the hell this happened.
Of course.
They're going to be pointing fingers at somebody. So there's one chance to get this right, and it starts on day one by making sure you get the documents and you hire the right professionals.
And I think you bring up an excellent point, Nick, because we do see it across the board, right? We've seen it where, the management company, they're able to obtain several properties from this same developer. So there is that friendly relationship. So it's important to ask those key questions, because you do have to keep in mind for all those board members is the first board member that gets elected is elected by the developer. And many times, as you stated, Nick, I know we've seen it where we take on an association that just did a developer turnover and they're switching management, and you can see all the relationships there, so it's our responsibility as management really to bring in the right professionals to do the job that's necessary, because if it's not handled properly today, the impacts can be devastating for many associations, maybe not in a couple of years, but it'll definitely be within 5 to 10 years. We saw it with an association that was less than 10 years old. They didn't do any Chapter 558 claim. They didn't go through any process. Their pool was completely kind of falling into the garage. It was later determined when an engineer was hired that this was something that just wasn't built right. So the owners would have to cough up that bill. And it was just a bad decision by that board, or maybe, as you stated earlier, it was a stacked board. So it's something that definitely has to be kept in mind. Misha, I wanted to ask you, let's say that the board takes the necessary steps and hires the proper attorney, hires the proper team. Can you tell me a little bit about what the process is of what your firm would do throughout this inspection period when you're assessing the building, and what are the key components that you're looking for to make sure that there's no issues?
Of course. The first thing, I'm sorry, the first thing that we would circulate immediately upon being retained is a unit owner questionnaire and a management questionnaire. And it is something that is web-based, that the unit owners and the managers and engineer local to the building would fill up. Why is that important? Because you will see, as I speak about the process, that's kind of the critical path of finishing the process. One of the questions we are asked is, how long until you get a report? And we give lump sum numbers for our report, which means that if I could do it and bill it in 48 hours, it would be great. However, that never happens. The actual number is between 90 and 120 days, and you would go, wow. The typical reason why it's happening is because there is a component of this inspection that is based on unit owners, and I'll get to it in a second, because in today's age of COVID, it's a very sensitive question. So remember, what we will go to inspect are the common areas, the limited common areas, and the individual units. What we are trying to find is what are all of the defects or issues that are present in the building. We used first-hand knowledge, which means we see it, we inspect it, we document it. We used mobile apps in order to document it in picture and in words. And we use also the knowledge of the people within the building. The manager and the engineer live, eat, and breathe that building every day. We're going to be there at best for a couple of weeks. There is no way that we can harvest the knowledge of being there every day, all day, in those couple of weeks. So we asked manager and local engineer, hey, what are the things that you observed? We don't just copy paste it. We actually individually and independently document each and every of those issues because you want to know, one, is it a real issue? And two, how important an issue it is.
Yeah.
Because sometimes we go into what I call emotional issues, which kind of clutter the claim in itself, and I get to that in a second. So we go out in the field armed with the questionnaire that the manager and building engineer have done, and we inspect from roof to garage or underground garage if it exists, all of the common areas. We document it, we independently confirm the issues, and at that point we to ask for the cooperation of the management company and the building manager to go into a given percentage of units so that we can establish if unit-based claims or unit-based issues are only an individual owner's claim or a building-wide claim. That's a long-winded way of saying the following. If toilet in unit 301 doesn't flush, frankly, it's the problem of unit 301.
Yeah.
If all of the toilet in the 3 line are not flushing, it's a building problem. And there is no way that we would know that until we look at the results of the individual owners' questionnaires in sufficient statistical number. So if a building of 100 units only have 2 of those questionnaire filled up, not enough.
Correct.
And we rely on the manager to probe, cajole or the majority of the people to come and answer those so that we can have an inside out look at what the individual owner's issue might be. We would go into the units at the time of our inspection. And that's not that bad because we can limit that to 1 person for building issue and 1 to 2 persons for MEP issues, only 2 to 3 people. We typically don't have a problem with that. I'll get to where we do get a problem. We actually document in enough statistically significant sampling that an issue is just unit 301 or it's building wide. And we compile a report that we submit to the board with a confidential engineering estimate of the value of the repair work should the association have to do it on its own.
Okay.
And it's an order of magnitude number. It's not vetted in the marketplace. The only real number is what the market tells you. We don't go to market with that. We use our engineering knowledge together with the licensed contractors that we have on staff who know how to estimate. So we give an order of magnitude to the association saying it's around this number. And also, these are the capital things that make the majority of the 80-20% rule. 20% of the issues are 80% of the cost.
Mm-hmm.
Here is the handful of Jerusalem issues that are actually the issues that are most important to the building. We know that unit 704 complained about the lint in the dryer, but that's not that. And I know that he or she is very vocal about lint in the dryer, but that's a $500 issue. Look at this $200,000 issue. Let's concentrate on that, because we don't want the developer and the insurance companies to go into left field and starting to address the $200, $300 issue while ignoring the major one. The way I named it Jerusalem issues, because if you can agree on that, you can probably agree on the rest. And if you can't agree on those, who cares with the rest?
Yeah.
Right? So in that context, you would actually isolate and bring to the association forefront those issues that represent the majority of the claim.
Okay.
We guide the association through that process together with Nick and the attorney that are selected, because that's kind of a dance. And I can't stress enough how the reputation of the law firm and the engineering firm influences the process.
Correct.
Do think about the fact that the collective fees of the attorneys and the engineer are a fraction of what the cost of repair or issue is. Sometimes an order of magnitude less.
Yeah.
And if you can't save money on both, where are you going to save money?
Of course.
Do you want to get the $3 attorney and the $2 engineer so that you collect $5? Or do you want the $5 attorney and $5 engineer to connect $100? That's kind of the thing where the multiple proposals and having to go with the lowest bidder is sometimes pushed either by boards or management. And we found several times Nick's and my firm are the second generation of.
Yeah.
So they try with the $2 guy. It went nowhere. The developer told them to go fly a kite. The building is disrepair. It's 2 years later. Some of the warranties are about to expire, and they come to us and they go, listen, we already spent $2. You said it's going to be $5. So for $3, can you just continue and finish this? And the answer is no. You need.
It's so true.
So if not us, do your homework.
Of course.
Do your homework and board member, association managers, do your homework in checking the results, the proven results of the people you are hiring. Nick's firm and my firm, we have an as-built of cases. And when a developer sits down with us, he knows he can't mess around.
There's a level of respect.
Find somebody of that caliber. It's best for you.
Of course.
Right.
And in the midst of all this with COVID and so forth, Nick, I wanted to ask you, because, there's buildings that are turning over probably as we speak. How are you recommending your clients when we're having 6, 7 people having to go into the unit? And with everything that we have going on with COVID, what are the recommendations that you and your firm are providing to your board of directors?
So it's obviously created an obstacle for both Misha and my office and management.
Mm-hmm.
There are certainly, just as part of the normal 558 inspection, Misha is going to want to look at a handful of units.
Yeah.
And that's going to be difficult, just to get Misha's team in, which may be 1 or 2 engineers to look at it. That may be doable. The owner may not object to maybe having 1 or 2 people in to look at certain things. Yes, maybe that's not so much of a problem. Or perhaps the management will figure out, well, these owners are out of town.
Correct.
We only need to get into a handful of units. These owners are out of town. These units have not been built out. Let's just work on those units. That's what we've been doing. If you're already past the 558, you got the turnover, you got the defendants wanting to do inspections. That's a much bigger problem, because Misha said there could be 50 people. Now,
yeah.
we certainly don't want, and we will not allow 50 people to come in. And what we've done is to say, who are the essential people that actually need to come in? This isn't an opportunity for you to browse, nice real estate and nice condominium units, which we see these defense experts come in and they start taking pictures of the yard and they think cool, and they're hanging on the balcony, they're looking at the view.
They're on their vacay.
That's not what this is for. Okay, if you
and bill for it,
it's not a bad deal. This is an opportunity to inspect. If you need to be in there, okay, we'll work with you to get in there. But it certainly creates a challenge, and we'll either go in shifts, so there's not a lot of people going into the unit at once. Well, if people need to look at things on the balcony, we walk towards the balcony and we close the door.
Okay.
Look at it from the outside, and then we come back through. So we try to look. We have to continue. The courts are pushing us to continue. They're not allowing these cases to just stop. So we have to do what we can within the confines of what is possible in terms of what management and unit owners will allow. And those concerns are obviously validated, and we have to deal with it, but we are dealing with it. Does it create more challenges? Yes. But can we get through it? We can.
Of course. And how about with regards to the arbitration? Are you seeing the cases moving along, or what's going on? How is COVID impacting that?
So we've heard from a number of judges that there'll certainly be no jury trials this year. And typically in these 558 claims, we always request a jury trial.
Yeah.
As opposed to a bench trial. Now, it's one thing to consider, well, are we going to do a bench trial? We want our case to go to trial quickly and not wait for jury trials to reconvene. That's a conversation we have with the board. And, and we can make that decision. Now, the opposite of what we've seen, because we've tried that with some 558 claims. And the defendants, they're no dummies. They knew that if they want a jury trial, they can say, and they've told us, no, we want a jury trial.
Yeah.
And because they know that'll delay it, because they know there can be no jury trial. So as Misha pointed out originally, as long as that money's with the carrier, better for them.
Correct.
They can delay the payment, better for them. So so while the association may be willing to forego it, we find the defendants are not, just to delay the case. There have been some pilot programs in terms of jury trials. There was one recently in Miami-Dade. It was kind of a non-binding trial, and the court was able to set up. Well, first initially they did juror selection through Zoom.
Okay.
So they didn't have a huge panel, because we've all been, I think most people have been to the courthouse, and it's, you go into a waiting room.
Yeah.
And you get assigned to a judge, and you go to the judge, and then they start picking the jury. Well, there's no way you can have 100 people in the courthouse.
Correct.
Yeah. So they did that initial selection online through Zoom. They asked questions, and a jury was selected through Zoom. Then those jurors came into the courthouse, 6 feet of separation. They had masks, they had gloves. Everyone was doing that. They all had their individual exhibit notebooks. And the trial proceeded like a normal trial would, except for everyone wearing a mask. And I think the consensus is, that worked out pretty well. But as the administrative judge said, well, in the biggest courtroom, they can only seat 39 people in their biggest courtroom. And most of these courtrooms are pretty small. So you can't really have a large case going on, or many cases going on in the courtroom or in the courthouse, let alone a courtroom, because of the limitations on the number of people that can actually fit. So there's a path. I think the jury selection and jury trial cases can proceed probably for smaller cases, but certainly not large construction defect claims where you have multiple parties, multiple expert witnesses, multiple days of trial. It's going to be much more difficult for those trials to proceed in this age that we have now. I think a lot of the judges are telling us that these types of cases will likely probably go to trial, certainly at the earliest next year, probably later next year. But at the same time, the judges are pushing us, and they have not allowed people to stop the case. They're pushing us for depositions. We've conducted a number of depositions through Zoom. Hearings are now through Zoom, which is great. It actually saves the client's money.
Yeah.
Rather than traveling to the courthouse, wasting time, parking, sitting there for 5 minutes to talk to the judge. Pull up Zoom, you argue your hearing, and then you leave.
Yeah.
That's actually been one of the positives in terms of litigation in general, is it's saving clients money on that. I did notice, Rafael, a question that I thought was pretty good. Do you want to, did you see that question?
Yeah, they have a question. They believe that the process before was more efficient than the process that's currently being done through the Chapter 558. Maybe if you can address, I think it was specific to the insurance. Maybe if you can address that question, Nick. Yeah,
there was about and I see this. In your opinion, has the owner contractor insurance program streamlined the 558 process, or has it made the settlement process more difficult? So I think Misha talked about insurance a little bit. So there's what we see in these projects is either each party will have their own insurance, their own general liability insurance. So you can have multiple, like Misha said, multiple adjusters, counsel handling insurance claims for each of the parties. So if you have 10 parties, you have 10 different adjusters, 10 different carriers working hopefully together to try to get a case settled. In a contractor-controlled insurance program referred to as a CSIP, or owner-controlled insurance program referred to as an OSIP, which a lot of the newer condominium projects have, everyone is under the same policy. So the developer, GC, subs, they're all under one policy. And the reason for that is to save the insurance premium for everyone up front, because the subs and developers don't have to get their individual insurance, which is simply passed along as part of the cost of construction. So they get one carrier in to say, hey, cover everyone in this project.
Okay.
That's referred to generally as a wrap, because it wraps everyone into one policy. So let's talk about what we see in terms of the benefits and disadvantages of that. The benefit is you're dealing with one carrier, one adjuster to try to settle. There's a point of contact, one person making all of the decisions for everyone, essentially, because they're going to settle the claim on behalf of everyone. That could be good if you have one good adjuster. We've had situations where the adjuster is not good. Other adjusters have replaced that adjuster, and then we've been able to get a resolution quicker. So the unfortunate thing, you're just dealing with one person, one adjuster, one carrier, who may be a very difficult carrier, who may not want to pay a dime until you're on the eve of trial or start a trial. So that's one issue. The other issue is we've seen with wrap policies, where it's one carrier making a decision, that carrier won't allow the association or any one of the parties to settle individually with the association. So you may have, and we've seen this happen, you may have, let's just say, the plumber. He has some issues, maybe $15,000 worth of claims against him. He's in the lawsuit. He would like to get out of it. We've gone to the attorney representing the plumber, because even though there's one policy, each individual party gets their own attorney. So we'll go to the attorney for the plumber and say, hey, look, it's $15,000. Let's resolve this and let's get it done. There's no point in us wasting fees, you wasting fees, fighting over $15,000 here. The attorney will agree, say, you're right. I'm gonna have to hire an expert that's gonna cost me $20,000, take depositions, deal with discovery. Let me see what I can do. The response in a lot of these situations is the carrier, because it's representing everyone, is gonna say, no, I'm not giving anything to the association. I'm not gonna give any money. I'm not gonna make it more easy, give funds to the association to continue to fight just to get rid of one person, because the carrier's still in it regardless. So you know what? I'm just going to pay for the expert fees. I'm going to continue to pay for the legal fees for this plumber for a $15,000 claim, and make it as difficult as possible for the association to settle the claim.
Wow.
So while it may be beneficial to have one party that you're dealing with and trying to settle, as opposed to multiple parties and multiple carriers, that's the disadvantage, is that it's difficult to weed out the smaller subs, the smaller claims, and focus on major claims, because as Misha said, the major claims resolve and push the litigation. Now, the benefit of having each carrier or each party having their individual carriers is you can do smaller settlements. And that's what we try to do, whether through repairs or money. Let's try to knock out the small claims. And if we can, great. This way we're focusing on, at the end of the day, I would like to be focusing on 2 or 3 major issues, rather than trying to, have a trial on multiple small issues with multiple parties. It just makes everything more complex, the trial more complex as it's longer, and you're trying to prove 50 different items as opposed to 3 different items.
Of course.
And so the wrap carriers know this. They know it's going to be more difficult, more expensive, and that's kind of the game they play and what we see.
Okay. And so I wanted to, in respect to you guys' time, I wanted to ask one last question and give you each an opportunity to answer. And I'll start with you, Misha. So you mentioned earlier that you've come in kind of round 2, or both you and Nick have had to come in round 2. What are some of the biggest mistakes that either management or the board make throughout this Chapter 558, so our listeners can avoid making those errors? You guys, from an engineering perspective, and then Nick, maybe from a legal perspective.
From an engineering perspective, the first error is not to hire the right engineers. And it's not me pushing M2E. M2E is one of the finest, if not the finest engineering firm in the area, but there is other fine engineering firm. do not hire your engineer based on price, hire him based on value. Because board 2.0 that will come after you will first look at what did you cede to the developer as a result of the 558, and that pool that the developer told you, nah, it's gonna leak because old pool leaks, is now leaking over the white convertible of the new president of the board, and he would like to know, why did somebody let that happen?
Yeah.
So that is number one. Number two, you need to, I know it's difficult, but you need to separate emotion from logic. Mm-hmm. And you need to listen. Hopefully you hired that good engineer and listen to the advices that he or she is making, in as much that, back to the $500 lint in the dryer issue, we know that some of the things are what we call emotional issues. But if your engineer tells you that they don't really have a case pushing that, and the developer is a sophisticated developer that knows that he doesn't owe it to you, you're really wasting your breath. So hire a good one and listen to them. That's typically the one or the both of the things that they didn't do when they had to hire Nick and me in the second round.
Excellent. Thank you, Misha. And Nick?
Yeah, I think I'll expand on that a little bit. I think, I think boards and attorneys and engineers need to approach this not in the terms of, well, how are we going to settle this? Let's get prepared for a settlement. It has to be, let's get prepared for litigation and a trial, because that's where these things end up. And in my experience, they don't settle within the 558 process. They always settle after a lawsuit is filed or close to trial, or even when trial started. So our approach is, you have to start getting the case ready for trial from day one. And that's the approach. And that has to be the mindset of the engineer, the attorney, and management. It can't be, well, we showed, and Misha touched on this, we showed, some locations for this, and we think it exists in all areas of the building, and hopefully developer will come in and fix it. No. What I want to do from day one is work with Misha to say, Misha, we got to approach this that not these guys are going to do the right thing. We need to show them, just like we're going to be showing a jury on the first day of trial. Okay, I need you to go look at all the locations, document everything, and tell me what's wrong with it. And then we're going to get an estimate as to what it's going to repair. This way, when we first sit down with the developer, or when we're starting trial, we have the documents, we have the evidence to say, this is what is wrong with this building. Okay, and we're ready to go. We're not floundering around. Okay, it's not that we don't know the scope of the issues. We know what the issues are, and this is how much it's going to pay. Either you're going to pay it now or you're going to pay it later.
Yeah.
And if you don't have that mindset going into it, the thing will just drag on, because the developers and the parties are just not going to, or the carriers are not going to take your position seriously. They're not going to think you're ready. Until you prove you're ready to go the distance, you're not going to be able to get the settlement that you want.
Correct. Excellent points, Nick. Thank you. And I want to give one with regards to the management side of it. It's as both of you have mentioned it, it's not just who you're selecting, but the quality of individuals that you're selecting, because the force that you're working against has a lot of money and has the backing of the insurance companies to be able to go on the long haul in these kinds of claims. So it's important to make sure that you not only select the right team, but more importantly, that you work together with the team. Because I have seen it where there's issues amongst the attorney and the engineer and whatnot. And it's important to make sure that you're working with a team that knows how to work together very well, so that the language they're speaking amongst each other, it's immediate, and the connection is quick, and the issues get resolved in a timely fashion. And it's very important. Same thing goes with the management as well. Making sure that if there are any conflicts, that they're clearly disclosed earlier on. If you're comfortable with it as a board, then you move forward. But just make sure you request that information earlier on, so you know what situation you're getting yourself into as a board of directors. So with that, I think we're going to wrap up the webinar. I want to thank you both, gentlemen, for being here today. It was honestly an honor being alongside both of you. You both have done excellent work in the industry, so I'm proud to be sitting here, I should say, in the screen next to you. And to all those board members and managers, thank you for attending today. The webinar will be available on recording on either through M2E, through Affinity, or through Siegfried and Rivera. And lastly, I want to thank the ladies again for helping put this webinar together. Thank you all, and we'll see you at the next webinar.
Thank you. Thank you very much, Rafael. Have a good day.
Thank you, Rafael.
Bye-bye.
Bye.